And finally, Richard Drabble QC, a most distinguished Queen's Counsel, at the top of the lists in any legal directory you care to name, in immigration, in administrative law, and so on.
I wanted to just to start, having kind of sat through a large part of the AGM, by saying these, of course, are difficult times. Wearing one of my other hats, which is as a social security lawyer, I'm well aware that the report stage of the legal aid, sentencing and punishment of offenders bill gets to the Commons next week, and those of us who have a practice over some years in social security are watching with bated breath to see whether anything survives in the way of public funding for social security tribunals, either at the first tier level, the upper tribunal level, or the Court of Appeal or the Supreme Court. In the face of the present bill, the answer is no. Whether that remains constantly the case, we will see. In your area, very similar experiences are going through. So it's all tough. I agreed to talk for 10 minutes max on Quila, and I think largely on the basis that it was a time we all had a fillip. Quila's quite a good story, and as I shall try to say, we do take some fairly important legal positives out of it. They may only be stored in the wind or whatever, but there are some legal positives. It's sensible for me, I think, to start by thanking the other players in it all. JCWI itself, my clients, who, like all my clients, were charm itself and bore it all with very great patience, but they really did. They were there from the victory in the Court of Appeal onwards, actually, in the court. My solicitor, Richenda Buxton, who's here now and put up with me not doing things until the very last minute with very great equanimity, I think. And my junior from Landmark Chambers, who's at the back of the court, Chris Jacobs. So before we come on to the positives, just one or two negatives. I was going to talk about Catgate, except I have to say, I always thought it was called Cat Flap, but and Cat Flap is actually right, I think. I have to say, I do regard it quite seriously. I don't very often say things like this, try and keep my head down, but pretty distressing to find a Home Secretary in a conference speech or anywhere else quite seriously advancing the proposition that the case was won on the basis of a family life involving the cat. I mean, you don't need to be an immigration lawyer to know that that was never going to be factually accurate. Quila's not been immune from this sort of spin. I don't think it's a party political spin. I mean, I think the spin has been present in immigration and social security and whatever for a very long time, and certainly the Blair government was capable of, the Blair and Thatcher governments were capable of dealing it. But Quila's not been immune. If you look at the way the publicity is being presented, what the government press releases latched onto was the acceptance by Lord Wilson that the forced marriage, the raising of the age limits to prevent forced marriages pursued a genuine aim. Well, so what? I mean, if you understand an Article 8 analysis, that's the very first hurdle that you have to get over. If the government isn't even pursuing a legitimate aim, then the whole thing is a nonsense. So the idea that the press release has managed to convey that the Supreme Court was somehow frustrating a legitimate aim pursued by government was, I have to say, just a Machiavellian misselling of what was going on. And I do find that sort of spin, which occurs all the way across government. It's not just immigration, but in a whole load of other things. And I say certainly not limited to this government, rather depressing. But right, where are the positives to be gleaned from Quila? You will all know that what had happened in Quila was that my client, Mr. Aguila Quila, and his wife were caught by the raising of the age limit to 21. In fact, they married when the woman was aged just under 18, so was caught by the old age limit, let alone the new one. But they were caught by it, and the argument advanced by JCWI on their behalf was that the raising of the age limit for an admittedly non-immigration purpose, that's quite an important part of the reasoning of Queen. I'll come back to that in just a second. But there was no suggestion that the legitimate aim that Wilson identified was an immigration control aim. They were not interested in immigration numbers. Instead it was said that the aim was the prevention of forced marriages, which are obviously a very great social evil, and it's impossible, no one would dream of wanting to pretend otherwise, but it's genuinely forced marriages. And so the basic idea that the government wanted to defend was the raising of the age limits would undoubtedly, so the government said, deter some forced marriages. That was pursuing a legitimate aim. The evil of forced marriages was so great that it was a proportionate response to a real social problem. And the easiest way of describing the legal gains I think we do get out of Quila is to go back, I keep on saying Quila, there was of course the other case, Beebe, which applied the same logic to an arranged marriage. And it's quite, Quila was, to a conventional English judge, a very attractive case on the facts, because it was undoubtedly a love marriage, and there was no serious dispute about that. But the real legal gains that can be seen out of Quila and Beebe together can be traced back, if you go back to Mr. Justice Burnett's judgment. He held in favour of the government, and the steps that he took to get there were, first of all, a finding that Article 8 was not engaged at all. There was no lack of respect for family life in the raising of the age limits, and accordingly there was nothing for the government to justify. And the basis for that view was the old, well-known chestnut and landmark case called Abdulaziz, in which the Strasbourg court had indeed held by a majority, 2 powerful dissents, that the failure to admit the male spouses in the clutch of 3 cases permanently to the UK did not show a lack of respect for family life, because, so the famous quotation goes, immigrants don't have the right to choose their place of residence. So no lack of respect at all, no need to justify. The minority said, no, that analysis is wrong. There is a lack of respect, but on these particular facts, in the pure Article 8 analysis, the interference which does take place is justified in the interests of immigration control. They were undoubtedly, unlike Quila, pure immigration cases. So, having got to that stage, Abdulaziz coming into play in the way that one would frankly have expected, I think, that it's such a well-known case, heavily relied on by Treasury Council, quite understandably. Having got to the stage that Article 8 is not engaged at all, you're left just with Wednesbury. The challenge has to be, to go anywhere, a allegation that the policy was irrational. And Burnett held in a powerful judgment that it wasn't irrational. It didn't matter whether you agreed with it or not, it was preventing some forced marriages, and that was a good thing. You couldn't say that Secretary of State had taken leave of his senses or whatever euphemism or metaphor you want to use for Wednesbury irrationality. So somehow or other, to get home on it, one had to crack that nut. You had to get out of an analysis which didn't get as far as proportionality. And we tried two things. So one was to distinguish Abdulaziz, well, three things actually, looking back. One was to say Abdulaziz should simply not be followed on this non-engagement thing. It seemed to me when they set out on this to be pretty bold. But we said it's an old decision. It was a majority decision alone at the time, and the UK court should simply not follow it on this aspect of it, not on the justification part of it, but on whether you get into A2 at all. The other argument was that you could distinguish it, because Abdulaziz was a pure immigration case, whereas this was a rule about something not to do with immigration. So the same logic just didn't carry across. And the third was to say, well, the common law has gone beyond Wednesbury. Anyway, we argued, took 5 minutes in the Supreme Court arguing the last point, trying to bury Wednesbury in 5 minutes, and I think they were quite split actually, but it doesn't surface at all on the judgment. We don't go anywhere in terms of Wednesbury being buried. But what happened in the Court of Appeal did distinguish Abdulaziz on the basis that the women in Abdulaziz were not UK nationals, whereas both in Kuyilo and Bibi they were. And so Stephen Sedley said, or Justice Sedley said, well, something different is happening here. You're exiling a UK national, and citizenship law demands a different answer. The Supreme Court weren't very attracted by that, and I was unsurprising on the facts, because all the women concerned had what would now be indefinite leave to remain, were plainly settled and were British subjects, if not British citizens, so not very interested in that. But what the Supreme Court did do, with surprising ease, was go back to the formulation that Abdulaziz was an old case. It was a majority decision with a strong dissent, and the Strasbourg court had not, in the line of subsequent cases, always analysed these problems in terms of no engagement rather than justification. And in paragraph 43 of his judgment, Lord Wilson said, I can pick up my little paper, having duly taken account of the decision in Abdulaziz pursuant to section 2 of the HRA, we should, in my view, decline to follow it. It is an old decision. So when I wrote that, never get away with that. It is an old decision. There was dissent from it even at the time, and then they go on to the line of subsequent decisions. So that does bury that first bit of Abdulaziz as to whether your Article 8 is engaged on these sort of long-term separation cases. 5 minutes, right. I've got to bury Wednesday. Yeah, when will I go? Yeah. And I don't know, then there's going to be anyway back from that. In a way, it's perfectly logical, because the Court of Appeal has been saying in the Kosovo case, for example, that Lord Bingham's comments in Rasgar shouldn't be taken as setting too high a threshold for the engagement of Article 8. Once you're beginning to say that, then basically Wilson says you get to the facts of Quila and you have permanent separation. It's a mega interference, not quite his language, but it comes pretty close to it. And that seems to me to be, I have to say, logical. So that's quite a big move, though, because loads and loads and loads of immigration cases are fought on the moment in this territory. So there's no need to get a justification. You're free to choose the place. You cannot dictate to the receiving state the place of residence. So that's big number one. Number two becomes, okay, you've got out of Abdulaziz. Where do you go now? What approach does the court take to proportionality? And here there was a major split in the court. Looking back on the way the argument went, I can now understand what on earth was happening, because Lord Brown was very hostile to my formulation, which was effectively, it was the court to come up with the right answer. It was an objective issue before the court. We'll see just what he says in the last 2 minutes of this talk in a moment. The majority just went straight for what they regarded as an orthodox analysis based on Denby schools and misbehaving. The test was an objective test for the court. It wasn't a question of deference. You just simply decided whether or not the measure was proportionate. And what Lord Wilson does in paragraph 46 is set out the quotation from Denby High School and then comments on what Lord Brown is going to say later. Lord Brown's court, he says, paragraph 91 below, for the courts in this context to afford to government a very substantial area of discretionary judgment is at odds with my understanding of the nature of that duty. And then he goes on to cite why. And so it's become a very powerful case that the test is objective, pretty well is. Did the government get it right? Not a question of deference. And so having got that far, the majority found it fairly easy to say, well, two things are certain. One is that you're catching a very, very, very large number of non-forced marriages. And two, you can't tell me, you, Secretary of State, can't tell me, the court, how many forced marriages you are preventing. So Lord Wilson sums it all up by saying this is a slow tremor to crack a nut, but the Secretary of State can't tell us the size of the nut. And so they go easily for the line that this was indeed disproportionate. Lord Brown was pretty unhappy with all of that. Well, his approach was that the court should follow government unless the government was plainly wrong, and you'll find all that set out in paragraph 91. And he says, unless demonstrably wrong, this judgment, the judgment of the government, should be rather for government than for the courts. Still more obviously, the comparison between the enormity of suffering within forced marriages on the one hand and the disruption of innocent couples within the 18 to 21 age group whose desire to live together in this country is temporarily thwarted by the rule change is essentially one for elected politicians, not for judges. So Lord Brown was a party to Whang, so there's a pretty big dichotomy in the effect, or the views to the effect of this line of case law. And there's some pretty graphic language which I won't read to you now, where Lord Brown deprecates the position. Part of the thinking, just to finish on this, is that if you, the court, are not careful about not exceeding where Strasbourg will go, the government is caught out. Government can't appeal to Strasbourg. The individual victim always can appeal to Strasbourg. So go carefully. I'm not really sure of the logic of that, but it's a part of the reason. And for all those reasons, I do think Quila is a little bit of cheer in what might otherwise seem to be fairly gloomy times. Thank you.